And it's Ken Kraetzer for Sons of the American Legion Radio. We are very pleased today to have a chance to talk with a good friend, and that is Richard Ensor, who is a commissioner of the Metro Atlantic Conference, also an attorney, graduate of Seton Hall, serves on numerous NCAA committees, and has done so much for sports, collegiate sports in the Northeast, bringing quite a number of championships to the upstate New York area, Albany and Buffalo in particular. Commissioner, how are you today?
Good, Ken. Glad to be with you.
Hey, thanks. Appreciate your time. And Monday, the Supreme Court of the United States came down with a major ruling, 9-0, in the NCAA versus Shawne, Alston, a running back, a football player at the University of West Virginia, a case that had worked its way through the courts. What did you see in that legislation, and why was it a 9-0 judgment by the court?
Well, we seem to be one of the few associations in this country that can unify disparate views on a court or in Congress against the NCAA. It's amazing, frankly, Ken, what that decision, the way it came down, particularly since as recently as a month ago, many of the NCAA leadership were saying we were going to win this case. I don't think many lawyers thought they were going to win it, particularly after the question and answering period when they presented in front of the court. And as it turned out, 9-0, that's pretty much a butt kicking in sports, as we say, right, Ken? And yeah. I would say we need to walk away from this and rethink how we view ourselves, particularly in terms of antitrust law and the need for us to change some of the ways we approach regulating our business.
And the two justices that wrote up the opinion, Justice Gorsuch and Justice Kavanagh, were very vociferous in their writing on this. And one of the things they pointed out was the amount of money that goes into college sports, into coaches' salaries and ADs. And why do you think the two justices were so vociferous in their opinion?
Justice Kavanaugh's dicta there is going to become headlines for many a future law review article, right? The NCAA is not above the law, and I think that's probably the reason. They just see the NCAA as not regulating salaries for coaches or benefits for programs or the building of these mega arenas and stadiums, but very willing to get into the details of how much athletes can receive in terms of their packages for scholarship packages and some of the other support services they need. So I think the justices weighed that and sort of tipped very heavily, particularly amongst the A5 conferences, to these outrageous salaries that we see, both commissioners, ADs, and coaches, and then the fact that all these funds are going into projects like stadiums, but not necessarily into supporting the athletes directly in their educational pursuits. So, in our world, the mid-major world, we're not paying those kind of salaries. We don't have those kind of facilities, but we certainly are going to have to live within the same law. And I think you'll see changes on the margins within the MAAC and other mid-majors. I think you may see some additional educational support provided to the athletes, whether it's computers or even internship program support, so that the athletes can have the same access to the business world if they want to do an internship, or international studies if they want to do that one summer, that the other students have on campus. So I think we'll see some changes in the MAAC. I think on the higher level, though, they're going to re-examine what they're doing, and they better start addressing some of these issues, because once you start unifying the courts, and Congress obviously is in the middle of the NIL discussion, we're going to get to that in a minute, we're going to be behind the 8 ball if we're not careful here.
Why were these educational benefits singled out in this case? Tutoring, opportunities for graduate school, computer costs. A lot of that you would think would have been just normal part of an educational package. Why did this become an issue?
Well, you have to go back to the original circuit court decision, which said that the NCAA had been overregulating and needed to open up the support services it provided to the athletes. And that's when we got to the cost of living adjustments, and we have that even in the MAAC in basketball, for instance. Our schools award not just the scholarship room tuition and board, but also an additional stipend based on the institutional's federal review of their packages that sometimes can go up to $3,000 to $6,000 additional direct support to the athlete to support themselves at that school. So that came out of that original case law, and the NCAA, in its wisdom or lack thereof, decided to appeal that to try to narrow the scope of what exactly could be regulated within that decision. And that's what was ultimately appealed to the Supreme Court, and that's why the justices in the Supreme Court they were kind of bound by the original circuit court decision on how they could address their case summary. So that's why you see those lists in there. But you have to look at that dicta and then look at what's happening in Congress right now with the NIL and within the NCAA itself, where we're talking about a lot of other rights that the student athletes will be able to access. So, yeah, right now the case law is fairly narrow out of the Alston case, but it's going to certainly change how we do business. And it also particularly said that the antitrust laws do apply. It removed some of the protections the NCAA had received from the Oklahoma State case, 30 years ago, I guess, at this point, which was the broadcast rights case. So they lost that protection given the Alston case decision that was announced on Monday. So, they lost on the merits, and then they lost some protections they had in previous cases. And that precedent goes away, and now the Alston case will become the defining precedent. And that's why Kavanagh's, statement about the NCAA is not above the law, the antitrust law, is going to be something people reference from here on in any case against the NCAA.
Yes, and Commissioner Rich Ensor, name, image, likeness is on the national news. As several states have already approved legislation that requires colleges to allow their players, their athletes, to earn income based on name, image, and likeness. And it goes into effect the end of this month, July 1st. And this is causing the NCAA to scramble to put a set of guidelines together for across the country. What's your thinking on this? This is seems like it's really going to change how students and athletic departments operate.
Well, it could certainly do that. And again, you have to scale it, because what may happen at the A5 level versus in the mid-major world could be very different, Ken. But the name, image, and likeness, the fact that it's taking place at the same time as the Alston decision is what has really become a student and athlete rights or welfare issues. What exactly can the athlete access in either educational benefits through Alston or through their own efforts to market their name, image, and likeness? Now, right now, most of that's prohibited under NCAA regs. There are some narrow exceptions, but this will open up the floodgates for any athlete to take advantage of it. Now, as the NCAA approached this over the last 18 months, they were looking to highly regulated still, understanding that they had to give some additional access by the athletes, but hoping that they could avoid certain things like conflicts with school marks or conflicts with school sponsors. And what started happening in California now is, I think there's 20 some odd states that have laws pending or approved. I think 6 or 7 of them will kick in July 1. So what's happened is the legislatures have stepped in and started providing state rights to student athletes to be able to market themselves using name, image, and likeness. And it runs the gamut from, just a general law that says these rights are owned by the athletes to some that are very specific and expand even beyond name, image, and likeness to things like medical benefits and so forth. So the NCAA approached it, like I said, 18 months ago. They've been working on it forever, and they were trying to regulate it so you couldn't have competing sponsors with the school. You couldn't use the school's marks. You could use your own name, image, and likeness, but you didn't have the right to use your university's name, image, or likeness. And there were a whole lot of these types of prohibitions, or what we were referring to as guardrails. And now, in the light of the Alston case, I think a lot of that's going away. So that's why you're reading about so much confusion. The NCAA was hoping to have a bylaw in place this week. I don't think that's going to happen. They're still debating it extensively. Just received an email from Mark Emmert earlier saying, the Alston case wasn't a great day for us, but we still have certain protections that we can exercise, and suggesting that we're going to have some minimalist approach to NIL this week or next, knowing that we can go back and continue to build the bylaw as we work through these issues over the next 6 months to a year. So I think you're going to see, at the high level, there's going to be a lot of activation around star athletes. But, at the end of the day, it's up to these individual athletes to market and their name, image, and likeness. It's a lot of work. They're already students. They're playing their sport. They may or may not be, intimately involved in the social media worlds of influencing and all that, where there's a lot of value here. You may want to run a camp at your hometown or participate in somebody else's camp and get paid for it. But, by and large, a lot of athletes may find it more work than it's worth in the short term. And that'll be interesting to see how it works in the MAAC. Now, I think we have athletes that could run camps at home or work with a coach at home running a camp. I think there's a few athletes that might have some, value for a sponsor. I could see in certain markets within the MAAC where, if you have an opportunity, if a player is going to come down to the pizza store, and they advertise it, and, there might be some value there, and he gets a little stipend and gets free pizza for the year. I don't know. But we don't even have coaches that have many name, image, and likeness endorsement deals. And they're, 24/7 in the public eye. There's going to be a fairly rare number of athletes at our level, I think, that can do this. Now, some of them may not be in our, high profile sports. One of the things people don't realize is that I think 9 of the 10 highest rated influencers in college sport are women. They're from women's sports, and they work these things all the time, whether it's tennis or swimming. And, they just are active in social media, and they have an opportunity here to perhaps monetize that activity. But, when you're doing everything else you have to do in college, finding another 10 or 12 hours a week to work on your name, image, and likeness efforts may be difficult. So it'll be interesting. So short answer is, I've been saying for a long time, let's not run around thinking our hair is on fire here. Let's just approach it, see how it happens, take it slow. If we need to, provide some additional services to the athletes in the way of advisement, that we could certainly work on that. But let's see how it goes. And I have a feeling at the top end, we're going to see where all the action's taking place.
Well, certainly, college students are very busy, especially when they're in season, very tight schedules, and managing this. Although I see so many athletes now being very active on Twitter from the day they sign a letter of intent. That's become a big ceremony now on Twitter to the school that they're going to go to. The question is, the apparel companies, the sneaker companies have had such an impact on college sports last 30 years or so. Are they the ones that maybe more proactive, as you mentioned?
Well, yeah, again, at the top level, I think it could be. Being active on Twitter and then monetizing that are two different things, as you know, as you build your own, you're building your own brand, right? With the radio show and everything else, it takes a lot of time. So you can have a following on Twitter, turning that into money. It'll be interesting. You have to really work with a lot of these sites in order to get that value added from being on the social media. I think the shoe companies will have influence in this area, but again, I think it'll be at the top level by and large. Again, there may be somebody local that wants to do it. Our schools generally have shoe deals already. They don't make the athletes wear the shoes if for some reason they don't want to. But if an athlete has a competing deal, they're going to have to work that out with the institution, whether or not they can use that during their competitions. So it's going to be some interesting days figuring all this out. But again, who's stepping up in the shoe company area to start paying all our athletes, significant revenue for using their product? I don't know.
Well, I know that, we cover college football, and the quarterbacks will probably be wanting to share their deals with their offensive linemen.
Oh, yeah. Especially if they want to stay quarterbacks for long and not injured quarterbacks.
Stay healthy, yeah. That's always said in the NFL. The quarterbacks take the linemen out to dinner once a week. Rich Ensor, are there guidelines that you'd like to see the NCAA try to implement for this situation?
Well, Ken, we're going to have two state laws. I think almost immediately we're dealing with the Connecticut and New Jersey. New York didn't pass I don't know if it didn't pass the Senate or the House. It passed one level and not the other. So I hear that's not getting voted on again until January. So I'm going to have two state laws that the schools are going to have to follow. They don't have any ifs, ands, or buts on this. So I'd like the NCAA to stay out of it as much as possible, frankly, because when the New York law comes into effect, we will try to, within the league, develop a baseline or the furthest reaches of the three laws as our ceiling of what we probably want to do. And I don't even know what that is yet, Ken. But we're going to have to try to manage it at that level. What I really don't need is a fourth level of NCAA compliance on top of all that. It's going to be very difficult to manage just with the three states that the MAAC schools reside within, without then also having the NCAA tell us what to do. So I'd like some very general guidelines. We signed off as a conference with what has been referred to as the alternate proposal that on NIL that is being debated this week and next by the NCAA Council. That was sponsored by the SEC, the ACC, and the Pac-12. And I think the Big Ten's pretty much in support of it as well. And that it provides two simple things. It says if you have a state law, you have to follow it. But these two things can't happen. You can't have boosterism impacting recruiting, and you can't have pay for play. You just can't pay people for playing. So those two general prohibitions which, by the way, are covered by any other existing NCAA bylaws on recruiting and so forth, would be the only things that you have to worry about above and beyond what the state law says. And then for the schools without state laws, they would basically follow those same prohibitions with some more details. So you'd have, if in absence of state law, this applies. And if you have a state law, comply with the state law, but you have to do one or two things to make sure that boosterism and pay for play don't occur. That's all the NCAA needs to do, in my mind, for the time being. And then we'll have to see what happens. We'll see how big the growth, we'll have to see how big a growth industry this is, particularly at our level. And then we'll also watch with interest to see what's happening amongst those A5 conferences and the big basketball conferences like the Big East and the West Coast, and see how they're managing it. But again, I think we can take it relatively slow in the MAAC as long as we comply with the state laws that are in existence.
Absolutely, and the outlook in Congress for legislation that would preempt the state laws is it would not happen until the fall at the earliest.
It sounds like it. You know, Mark Emmert, the president of the NCAA, was promising that forever, but he hasn't delivered on that. Again, we've unified both branches of the government, both branches of the legislature, the Democrats and Republicans, and they all agree the NCAA needs to be regulated. It's just to what extent. And I think the NCAA was hoping for a bill coming out of one of the congressmen from Ohio, which was going to provide some antitrust protection, but also grant certain NIL rights to the athletes. There are other bills, Senator Blumenthal in Connecticut, Senator Booker here in New Jersey, have proposed much more extensive bills that get into areas like not compensation, but for long-term medical care for injuries, the ability to get graduate degrees as part of your package with the institution. A lot of add-ons that could get pretty expensive, even for the MAAC schools that don't have a lot of activation of NIL. So I think that's going to have to sort itself out. I don't think it's getting done this week or next. It's probably going to be the fall.
Yeah, health insurance long term, I think, is such an important issue for athletes who incur an injury and need treatment ongoing after that. Rich Ensor, we appreciate your time. How about a final thought about how your conference did? You guys did an extraordinary job. I know we followed during the basketball season very closely how you had to change schedules on a daily basis and coordinate travel. How do you feel your conference came out of that whole extraordinary year and is set up for hopefully a back to normal year this season?
Well, I think we did. I really think the staff did a great job. They worked with me and the schools to make sure we were able to accommodate all the various pauses and schedule changes that we ran into during the course of the year. Of course, Iona, which your alma mater, certainly had its challenges, and yet they were able to come out of it and win the championship. So I think it was fair to everybody, but it was extraordinarily difficult. I mean, we were literally every night, sometimes up to midnight, redoing schedules, trying to really be fair to the athletes and the coaches. I think by and large we did well. We did it with about a third of the normal staff. So, and then when we got to the tournament in Atlantic City, I was able to go out and hire on a independent contractor basis a lot of staff that used to work for me. I brought them in for the week. So it was like an alumni event, but it allowed us to really run it the way it's supposed to be run. And that, we wanted to provide that level of service. And I had a couple of our alumni working on the COVID program, and we tested everybody every day. Cost over $200,000 to run those tests just for the basketball tournament. Officials, wow. Staff, all the athletes and coaches. And it went off without a hitch. So I can't say enough about how well the staff worked on this whole thing.
We certainly could see that at a high level, the amount of changes. Iono had 50 days of their practice and game schedule time canceled, and all the adjustments that had to be made. And just a final thought, you set up quite a number of tournaments and between men's and women's basketball for upstate New York and ice hockey in Buffalo, NCAA tournaments, several of which had to be canceled. Is there an outlook that some of those events can be rescheduled in the near future?
Yeah, we expect that we will get some of that back. I'm not sure when. Those contracts are out pretty far already. But we have NCAA men's first and second rounds this year up in Buffalo we're hosting. And then I know we have the women's super regional. It's going to be a new format in 2023 in Albany. And we have NCAA rowing coming back in Mercer Lake, and then I think we have another NCAA men's basketball on the forecast. So we need to return men's basketball to the Albany venue. They lost that, but the NCAA will want to come back. They'll want to come back because these sites have been really good for them. They sell out. We run them the way they like them run. They're easy to get to because we have good air service and good hotels and plenty of, interstate access. So when we do something in Buffalo, it's just as easy for the Ohio and Michigans to get there as it is the Eastern schools. So it's a great site for that reason alone. I don't think Frozen Four is on our agenda again for a while. I think we'd like to get it back. It's got a few problems these days in terms of they may be overpricing it a little bit in terms of what, the draw is. And they've also had some issues relative to the way that they award tickets based on past history. But then if the schools that, those fans represent don't get to the Frozen Four, they dump them right at the Frozen Four. So you can't sell out because you're reselling tickets from people that brought them back. So I think they have some real issues they need to work out and I don't think Buffalo will want to sign up for it again until those are resolved because we want to see sellouts. So you put all that effort into it for a year or two, you want to see a sellout. It just wasn't set up for that kind of success this past time we hosted it.
Well, Commissioner Rich Ensor, you have done so much for college athletics in the Northeast, running your leadership for the Metro Atlantic Conference over 30 years. And
33, Ken. I'm the longest serving commissioner. Doug Elgin just retired from the Missouri Valley a week or two ago. He was 2 months longer in term than me. So there I am, last person standing. But I've got a couple of years to go still. I just got an extension through June of 23. I'll be 70 then. So I could probably still do this job. I'm not sure I want to do it 24/7 by that point. I might want to just look at doing some consulting work at that point.
Well, I have to say, I think, I've known you really since you joined the Metro Atlantic and followed your career. I think you did some of your best work this past year, keeping everything together, being able to help run get the championships run, get the schedules played out, and doing it with a bare minimum of resources. You provided tremendous leadership to college athletics.
Yeah, and I appreciate that. Yeah, we try. Experience sometimes does help. So, you just understand at some point that, the sky is not falling. We will figure this out if we just work together. And it was just making sure everybody would work together that made it happen so well.
Well, very strong leadership capability, and doesn't hurt to be a lawyer, I guess, sometimes.
When I first got the law degree, Ken, I said, well, if nothing else, if they don't want me to be commissioner, I can always do insurance law. So, but it's worked out pretty well for me.
Thank you for your time today. It's always a pleasure to chat, and we see the work that you do providing leadership for the colleges in the Metro Atlantic and on a broader basis, college athletics. So it's really a pleasure to have a chance to catch up today.
All right, Ken. Good luck with everything. See you down the road.
Okay. Thank you, sir. Rich Ensor, Commissioner of the Metro Atlantic Conference. And this is Ken Kraetzer for Sons of the American Legion Radio from my home office in White Plains. Have a great day, everyone.